Good morning.
Good morning.
So I got your motion relative to child support. Um, and the motion claims that his child turned 18 and graduated from high school. So I contacted them, the front of the court anyway, so they could confirm that, because generally that's all you need. All you need to do is send a copy of could be a diploma, could be the high school transcripts. Once they get proof of that, they'll stop the child support. Okay. The problem is um, uh, they can't. Apparently, Mr. Brown does not have access to that information. So let me first turn to Mr. Brown, and then I'll hear from Miss Dennis. Is that correct, Mr. Brown? You can't figure out if this child did in fact graduate?
I hold on. What I just pushed this start video thing.
Go ahead.
I can't get the camera to come on.
But you don't have to. I can hear you just fine.
Okay. They've been in Detroit for like 6 years or something. So, but I have like Facebook stuff. I got pictures of her graduating. She graduated in May of last year.
Hang on a second. All right. Well, this should be easy to figure out. Miss Dennis.
Yes. Yes.
Do you know what we're talking about here?
Yeah. Let me just start off by saying this. Yes, it's going on 7 years that I've been here in Detroit.
Welcome back, everyone. Today, we're diving into a tense child support hearing that's loaded with emotion and legal complexity. On one side, we have Mr. Brown, trying to prove his child has graduated and that his obligation should end. On the other side, Miss Dennis, who has been carrying the responsibility and is asking for support to continue a little longer. This case has everything: family drama, legal intricacies, and conflicting perspectives that highlight the human side of the law. Stick around as we break down the key moments and reveal what the law really requires.
Talked to my daughter since she was 12. She had life monumental moments. Graduating prom, she in hair school. She graduate November of this year. So he never reached out to say congratulations, never, nothing on nothing. But it's temporary for him. It's a lifetime for me. She's 18 and she transitioning. She paid for cosmetology school out her pocket, trying to make ends meet. So that little bit do help. And as far as the child support goes, he ready to put an end to it because he don't talk to her. He don't talk to me. I done reached out, text him and everything, and it's nothing. But he could go down there to the court and say that she done and this and that. He got pictures when he don't even talk to her. My baby going through what she go through behind him. And I would like for the child support to continue on until her to the end of her 19th year. It stopped in September. The court told me it stopped in September of this year, but I would like it to go to her 19th year because I still have expenses with her. It don't stop for me, but it stopped for him, and he wrote that motion. She done with school. She done with that. He want to wash his hands of her completely, and I feel like that's so unfair that I didn't lay down by myself. I laid down with him. And not once.
Now watch closely as Mr. Brown fumbles with his camera and tries to provide proof through Facebook photos. This is a classic example of a parent relying on informal evidence in a legal setting. Notice how even simple procedural steps, confirming graduation, can become stressful and emotional. The judge is calm, professional, and steering the conversation, but the tension is palpable. It's a reminder that the courtroom isn't just about law. It's about people trying to navigate rules while emotions run high. Could he have handled this better? Let us know in the comments.
He contribute to anything. In 3 years, I came down here and I lowered his child support to $35.
Yeah, right.
If you see it in records, you look in your records, see it in the record, me and him came down to the courthouse. I lowered the child support down to $35 only on the strength of He'd get her on weekends, get her on holidays, get her on summer vacation. And he couldn't do that. And I had to wait 3 years to raise the child support back up because he still refused to participate. So
okay. All right, I got the picture. I want to tell you both something. There's a lot of things I can do sitting here today. But there's two things I cannot do. And I hope the parties understand. I can't make somebody a good father or mother. I can't do that. I wish I could. Because if I did, I would have probably very few of these cases. But I can't do that. And I wish I could. Because I think your daughter deserves better. She deserves something. The second thing is I cannot violate the law. Okay? I have to follow the law. And the law in this case.
Here's where the emotion hits hard. Miss Dennis recounts 7 years without meaningful contact and the sacrifices she's made to support her daughter. She's not just asking for money. She's highlighting the reality of parenting and the gap between obligation and engagement. Her words expose a tension that many single parents face. Child support isn't just numbers on paper, it's about ongoing responsibility and care. The contrast between pictures on social media and the lived reality adds depth to this drama. Who do you empathize with most right now? The absent parent or the caregiver? Comment below. Asterisk.
Says that someone can collect child support until the child is 18 or graduates from high school, whichever occurs later. Now, she has done that, okay, by everybody's admission. So the law says that I have to terminate his child support, but I am doing it effective the date he motioned me, which is the first charge date. He motioned this on January 9. So the first charge date, somewhat close to that, is January 1. So I'm going to grant the motion to terminate child support effective January 1, 2025. And what you need to do, Mr. Brown, is you need to come to the courthouse on the 5th floor Legal Assistance Center and prepare an order for me to sign, which you need to send to Miss Dennis. And the order says that your child support
Now pay attention to the judge's commentary. This is pure judicial wisdom. He makes it clear. He can't force someone to be a good parent, but he can follow the law. This is a powerful moment because it highlights the limits of legal authority. The judge balances empathy with strict adherence to statutes, explaining how child support ends when the child graduates or turns 18. It's a reminder that fairness and law don't always align perfectly, and the court has to navigate that gap carefully.
For this child terminated on January 1 of 2025, and I will sign that. And I wish everybody the best. I wish your daughter the best.
Say one thing,
Sir, yes, sir. Can I say something too? I'll let her go first.
Stop.
Go ahead, ma'am.
Right. Go ahead, real quick.
Hey, so the courts told me that the child support is ordered all the way until September of this year. So you throwing that order out?
There's no order saying that.
That's what the courts told me. That I called it.
I should tell you this, Miss Dennis, that unless you have paid the person to give you advice, you shouldn't rely on it. Okay? Mm-hmm. Because what I'm thinking is they may have told you what happens if she's still in high school, maybe not. Child support goes until someone graduates from high school or turns 18, whichever is later. I've had a lot of 18-year-olds still getting child support because they haven't graduated high school yet. I've had a lot of 19-year-olds who get child support because they haven't graduated high school. But this child has graduated high school and is over 18. And
here's where the legal mechanics kick in. The judge explains that child support must terminate because the child has graduated and turned 18, but he aligns the termination with the date of the motion. This is a subtle yet critical detail. Procedural timing matters. Mr. Brown's obligation ends January 1st, 2025, even if the child graduated earlier. This is a perfect example of how legal outcomes hinge on paperwork, filings, and timing, not just personal circumstances. Viewers, notice the precision. The law is strict, and even small dates can make a big difference.
the law says I have to stop it, but on the effective date of a motion to stop it. This motion was filed January 9. So the closest charge date I have is January 1. And that's as far as I can stop it. Like I said, all I can do is follow the law. And that's what I have to do. Now, Mr. Brown, what can I do for you?
Well, I got two questions. You said go over there to the 5th floor and get a what, man, sir?
Mr. Brown, you're getting yourself into more difficulties. You really need an attorney to help you because, so I need you to go, you know where the courthouse is?
Yes.
On the 5th floor.
Right.
It's called the Legal Assistance Center.
Right.
I need you to go there and they will help you prepare an order terminating your child support effective January 1, 2025, and that all arrearages are preserved. Period. That's all you got to do. And then they will prepare the order. You got to send a copy to Miss Dennis at her last known address. You send me the original. If nobody objects within 7 days, I'll sign it and you will be done.